People almost never stop paying HOA dues out of defiance. It's a job loss, a medical bill, a special assessment that landed in the same month as everything else, or a dispute where withholding felt like the only leverage left. Whatever the reason, the question underneath is the same one. What actually happens next? Not the worst case somebody posted online, and not the reassurance that it probably won't come to anything. The real sequence. Because this is a process with defined stages, and almost every stage has a point where it can still be stopped. The expensive mistake is not missing a payment. The expensive mistake is not knowing which stage you're in. Here is the shape of it. Missing one payment does not put your house at risk. What puts your house at risk is a balance that sits unaddressed long enough to move through 4 stages. First, the late fee and interest, then collection costs and attorney fees, then a lien recorded against your property, and then, in most states, foreclosure. That last one surprises people the most, so let's be direct about it. An HOA can foreclose on a home whose mortgage is completely current, because the HOA's claim is separate from your lender's. Each of those stages has a trigger and a timeline, and both are set by your state's statute and your community's governing documents, which is why the honest answer to almost every question here starts with where you live. The first thing that happens is a late fee, and this is the stage where people assume the association can charge whatever it likes. Often it can't. Several states put a statutory ceiling on the late charge. California is the clearest example. The late fee is limited to $10 or 10% of the delinquent assessment, whichever is greater, unless your governing documents set something smaller. That is a cap, not a target. And if your ledger shows a larger charge than your state allows, that is a real dispute worth raising in writing. But notice the condition attached to every protection in this episode. Nobody applies it for you. An overcharge sits on your account earning interest until you name it. Interest is the stage that quietly changes the arithmetic. In California, the association may charge up to 12% a year, beginning 30 days after the assessment came due. 12% on a few $100s sounds survivable, and for a month or two it is. The problem is that interest runs against the whole delinquent balance, and the balance is growing at the same time from the next month's assessment and the next late fee. 2 things compounding in the same direction is how a homeowner who thought they were $400 behind opens a statement showing $2,000. And in most states, there is no statutory rate at all. Whatever your governing documents say is what applies. This is the stage that does the real damage, and it is the one people never see coming. When the association hands your file to a collection agency or a law firm, the cost of that referral generally gets added to what you owe, not to the association's budget, to your ledger. A $400 delinquency can become a $2,000 problem without a single additional missed payment, purely from fees. There is one piece of leverage here worth knowing. When a genuinely third-party collector is involved, federal debt collection law governs how they may behave, including your right to demand validation of the debt in writing. That right is about their conduct and the accuracy of the amount. It is not a way to make the underlying assessment disappear, and anyone who tells you otherwise is selling something. Laid out end to end, the path looks like this. A missed assessment, late fee and interest, a collection referral that adds costs, a statutory notice telling you what is owed and what happens next, a lien recorded against your property, and finally a foreclosure action. Most states require that notice step before a lien can attach, and that notice is the single most important piece of mail in this entire process, because it is both the warning and, in many states, the start of a clock you can still act inside. The people who lose homes over assessments are very rarely the people who read that letter. A lien is a claim recorded against the property. It matters in 2 ways. Practically, it sits in the chain of title, so a sale or a refinance will surface it and typically will not close until it is resolved, which is how a lot of owners discover one that has been sitting there for a year. Legally, it is the foundation for everything that follows, because the association cannot foreclose on nothing. That is also why the procedure matters. Many states require a specific notice, with specific contents, delivered a specific way, before a lien may be recorded. When that procedure is not followed, the defect is not a technicality you feel awkward raising. It is the defense, Here is where your state matters more than any other fact in this episode. California sets a floor. The association generally cannot foreclose unless the delinquent assessments reach $1,800, and that figure deliberately excludes late charges, collection costs, attorney fees, and interest, so the fees cannot be used to inflate you over the line, or the debt is more than 12 months old. That is a genuine protection. Now the uncomfortable part, most states have no such floor at all. In much of the country, an association may pursue foreclosure over a few $100s in assessments, and whether a judge has to approve that sale depends on whether your state uses judicial or non-judicial foreclosure. Same missed payment, radically different exposure, decided entirely by geography. This is the single most common misunderstanding, so it deserves its own beat. Paying your mortgage does not shield you from an assessment foreclosure. They are separate claims, and the associations does not wait in line behind the banks. There is a wrinkle worth knowing. Your mortgage servicer may notice the delinquency, pay the association directly, and add that amount to your loan balance. If that happens, it is not generosity. The lender is protecting its own security interest. The immediate threat to the house recedes and the money is still owed, now to the party that can foreclose on the mortgage instead. It changes who you owe. It does not change that you owe. 4 things, and they work at nearly every stage. First, demand an itemized ledger in writing. Every charge, every date, every fee. You cannot dispute a number you have not seen broken out, and ledgers contain errors more often than anyone admits. Second, ask for a payment plan early. Some states require associations to offer one, and an association that has not yet paid a lawyer is far more willing than one that has. Third, if you dispute part of the balance, pay the undisputed part and say in writing that is what you are doing. Withholding everything converts a fee dispute into a delinquency and hands away the argument you were trying to make. Fourth, put all of it in writing. A friendly phone call with a board member is not a record, and this process runs on records. Be honest about where the line is. Ledger questions, fee disputes, and payment plans are things a homeowner can handle in writing. Once a document arrives with the words lien or foreclosure on it, the stakes stop being proportional to the effort of a phone call, and the deadlines in that document are usually short and unforgiving. If a notice period is running inside the next 30 days, that is not the moment to research. It is the moment to get someone licensed in your state, looking at the actual paperwork. And do not assume that is unaffordable. Many states fund legal aid and HUD-approved housing counseling for exactly this situation at no cost to you. So, to hold on to. This escalates in stages, and knowing which stage you are in tells you what is still available to you. The dues themselves are usually not what becomes dangerous. The late fees, the interest, and above all the collection costs are. Your real exposure depends enormously on your state, from California's $1,800 floor to states with no floor at all. A perfectly current mortgage protects you from none of it, and everything you do here should be in writing, starting with the demand for the itemized ledger. If you are somewhere in this sequence right now, that ledger is the first move, and it is one you can make today. Sources for everything cited are on screen and listed in the description. This is general education, not legal advice. Assessment collection, fee caps, interest limits, lien procedure, and foreclosure thresholds all vary by state and by your own governing documents. If you are already in this process, the written breakdown and the letter templates are linked below, and the first step is always the same. Get the itemized ledger.